roll?
We are. It is about 7:01, Susan.
All right, let's do it. Good evening, everyone. Welcome to you all from the International Dyslexia Association Northern New England Alliance, serving Maine, New Hampshire, and Vermont. I'm Susan Horahan, the current president of IDA-NNEA. Welcome to our Read for Parents webinar featuring Amy Phalon tonight, an educational lawyer supporting students and families with dyslexia. As a branch, we're thrilled to provide these Read for Parents webinars every other month, which focus on different IDA fact sheets and areas of interest to families and educators. The IDA fact sheets are a great tool for informing families and professionals alike on the journey of dyslexia. As many of you parents and practitioners can probably relate, getting structured literacy instruction for adults in need is more often than not a difficult journey for parents, students, and teachers. As a branch, we are honored to bring these informative sessions to you as we work to bring structured literacy to all students in all classrooms, and especially to those who struggle. To support today's session, we have Andrea Pollock managing the technical aspects of the webinar. Chris Riley is not able to make it tonight, but we will be adding links and resources in the chat as we go along. And Heidi also is not able to join us, but Andrea and I will do our best to facilitate the question and answers at the end and throughout the webinar. We do not offer certificates of attendance for these Read for Parents webinars. During the session, please use the chat to ask questions. And at the end, we'll have 20 minutes or so for more questions and answers. Today's webinar will be posted on our website within the next week. Please consider joining our branch. There are many advantages, including connecting with our community, staying informed, great deals like IDA TV, and expanding your network. Our next Read for Parents will be June 14th, and then again on August 9th. And coming in October, we will be holding our 2-day live virtual conference. Be watching for more details to come. There are a variety of membership levels, as you can see here. We have membership levels for parents, professionals, teachers, advocates, students. One will surely fit your needs. Our branch has a number of activities that we offer, including these every other month Read for Parents, a Wilson collaboration 2 times each year, our annual virtual conference, which will again be at the end of October. Our annual Project Read webinar is held in February and sometimes into the beginning of March. Our newsletters will be coming out in February and August, and we do offer scholarships. So we'll put that information out as we get closer to our conference. And now it is my pleasure to introduce our speaker for this evening, Amy Phalon. Amy Phalon has been advocating for students with disabilities for close to 2 decades. She spent the earlier part of her career teaching English, which led to a deep concern for how students with dyslexia and other learning disabilities were often shortchanged by general education reading instruction. As an attorney, she has been working primarily on behalf of children with disabilities and their families to obtain appropriate special education and related services under the Individuals with Disabilities Education Act, known as IDEA, and also the Americans with Disabilities Act, or the ADA. Amy has handled cases at all levels, from advocacy at IEP team meetings to due process hearings, judicial review, and federal court appeals. Recent cases have involved representing families of students with learning disabilities, students facing disability discrimination in school sports, students facing racial discrimination in school, disability rights cases involving college students, and cases involving families with disabled children facing housing discrimination. Amy served on the board of directors for Disability Rights Maine for 6 years. She is currently a member of the Council of Parents, Attorneys, and Advocates, known as COPA, a national organization dedicated to protecting the rights of students with disabilities. And she's also a member of the International Dyslexia Association. Amy is a graduate of Colby College in Waterville, Maine. She earned a master's degree from Middlebury College's Broadloaf School of English and her law degree from the University of Maine School of Law. So join me in welcoming our guest speaker, Amy Phalon.
All set, Amy.
Hello and good evening, everyone. I'm really honored and happy to be here this evening. Hoping my screen has shared appropriately. Okay, so far so good. So my name is Amy Phalon. I am an attorney working on behalf of students with disabilities and their families. I am based in Portland, Maine, and my law firm is Miller and Phalon. I have another partner, Amber Miller, who also works in special education law. And then we also both do quite a bit of juvenile justice work as well. So those two things often overlap, and she found her way to education through the juvenile justice work, and I found my way to the juvenile justice work through the special education. But needless to say, dyslexia is an issue that a lot of families face that has been near and dear to me for many years. I taught students at the college level who were placed in remedial reading programs where they were being taught reading strategies. And I realized sort of halfway through my first semester teaching this course that the students really lacked reading skills. And that's what drew me to special education law and trying to advocate for better services for students. So I wanted to first just start out. This is my contact information is here on this slide, but you can also get it through the IDA after the presentation. And don't hesitate to reach out by email or phone at any time if you have any questions or need some more information or resources. I'm always happy to talk about these things. Right, so have another opportunity for everybody to type something in the chat. I'm wondering, as you are advocating for your own children or other students, what you're facing in your state or in your school district that's most frustrating. And I listed some options here: identification, diagnosis, early screening, eligibility for an IEP or a 504 plan, IEP development and design, IEPs, specially designed instruction, service delivery, FAPE, which is free appropriate public education, access to general education, content area, or something else. So take a couple minutes and type something in the chat. So looks like a lot of eligibility, screening. The district's literacy curriculum undermines the OG instruction the student is getting outside. That's a big one. Identification, lack of understanding of double deficit dyslexia. We're going to talk about that. Eligibility, screening. Issues getting OG trained providers. That's another big one. No qualified staff, service delivery and fidelity. Yes, it's one thing to put it in the IEP. It's another to deliver it with fidelity. Well, it looks like probably the biggest thing is lack of OG providers. That one keeps coming up. Personnel are not trained. All right. Great. Well, thank you. So how I've structured this is to kind of give a basic overview of the federal law and then go into the special parts of that law that pertain to the identification and service delivery for students with specific learning disabilities, including dyslexia. I have 3 or 4 cases I want to kind of dive into. These cases, I surveyed the whole country. I was looking for circuit court cases, and I found the most recent and interesting cases just happened to come out of our Northern New England circuit. I think Vermont is actually in the 2nd Circuit, but Maine and New Hampshire and Massachusetts, we're in the 1st Circuit. So we do have some very recent and interesting cases about getting structured literacy instruction into a student's program. And then I have another case out of Nevada, which is similar. So I think that we are going, in terms of case law, we are going in the direction of requiring schools to put methodology and structured literacy in the IEP and having to deliver it. I'm also going to go over some of the state legislation that pertains to students with dyslexia and how that has changed. It's actually really kind of exploded over the past 20 years. States have added dyslexia legislation and requirements for schools, teacher training programs, and various other things. So I'll go over a little bit of that. And at any time, if you have a question, feel free to type it in the chat. I will stop at certain points and check in to make sure that I'm not either going too fast, too slow, or have missed something. So So just as a brief overview, for those of you who are new to special education law, welcome to the jungle. There are really 3 main components at the federal level of special education law. And we have Section 504 of the Rehabilitation Act and Title II of the Americans with Disabilities Act. And these laws prohibit schools and places of public accommodation from discriminating against people on the basis of disability. So you're probably familiar with the term 504 plan. That's when a student is eligible under these 2 laws, the student will receive a 504 plan, which is really about access. A lot of it is mostly accommodations to be able to access the general education curriculum. There is a FAPE requirement, free appropriate public education, under Section 504, but it's weaker than the requirement under the IDEA. Actually, I want to just mention one other thing. Most of what I'm going to talk about is kids in K through 12, but as kind of an aside, when a student goes to college, and some of the families I've worked with, I've been with them from, all through, and they do go to college and they need accommodations, and their accommodations come through these 2 laws. They can get extra time, access to technology, and things like that in order to access the curriculum. So the strongest civil rights law to dealing with students with disabilities in public schools is the Individuals with Disabilities Education Act, or IDEA. I put the citation there. That's 20 U.S. Code, Section 1400, and it goes on. It doesn't stop. It goes to like 15 something, and that pairs, so that's the statute passed by Congress, and that pairs with the regulations that are developed by the Department of Education. And all of those regulations are at 34 CFR Code of Federal Regulations, Part 300. And again, it goes on and on. If you are really interested and you do not already have, I highly recommend the, probably backwards, the Special Education Law book that is published by Rights Law. It's got the whole statute with explanation and some of the most important cases. The legislative purpose to the IDEA is to ensure that all children with disabilities have available to them a free, appropriate public education that emphasizes special education and related services designed to meet their unique needs and prepare them for further education, employment, and independent living, and to ensure the rights of children with disabilities and parents of such children are protected. And this purpose it just says it all, I think. We don't want children with disabilities to be excluded from school. We want them to have an appropriate education that meets their needs. And this is a right, this is a civil right for all children. So when it comes to statutory provisions that are related to the specific learning disabilities, the number one thing is really identification and eligibility. So specific learning disability is how the IDEA captures dyslexia, dyscalculia, dysgraphia, and other learning disabilities. So it doesn't say specifically on your IEP form dyslexia, but it's only because it's captured in specific learning disability. So dyslexia does count under the IDEA as well as Section 504 as a qualifying disability. In order to be eligible under IDEA, not only does the student need to have the qualifying disability, but she also needs to have special education and related services in order to access her education. And sometimes this can be a very difficult, it seems like a very simple determination, but it can be just hand-wringing going through these things with the school districts. I'm sure some of you have been there. In 2004, when Congress reauthorized the IDEA, they added some additional procedures for identifying children with specific learning disabilities. And it used to be that school districts relied on what's known as the severe discrepancy model, where the student, if the test scores show that the student was bright and smart and had a high IQ or average to high IQ, but they were not reading, that was required for them to actually qualify for special education. That didn't catch enough students, so Congress expanded it and they added a provision that to determine the existence of a specific learning disability, the IEP team, first of all, needs to have some additional people. So when the question is whether or not the student is qualifying with dyslexia, the IEP team needs to bring in and make sure that there is a teacher who is actually working with the student, preferably the classroom teacher who is with that student on a regular basis. And if the student is not in the general education classroom and there is no general education teacher working with that student, then the teacher that the student would have. So they have to bring in a teacher from the same grade who would be teaching the content area that the student would have if she were in the general education curriculum. And in addition to that, someone who is qualified to evaluate students for dyslexia needs to be at the IEP team meeting. With an IEP team meeting that's not determining eligibility for the specific learning disability, you only need someone who can interpret the data and the results of the educational assessments, but for someone with a possible specific learning disability, you need someone qualified to administer those tests so that they have that particular expertise about learning disabilities, what it looks like, what the test scores mean. So a student who is not achieving adequately for their age or meeting state-approved grade level standards in any of these listed areas is likely going to qualify for as a student with a specific learning disability. There are some other qualifications you need to look at, but if a student is not achieving as expected in one or more of these areas, that's a key part of the determination. And you'll see that we've got 3 of them having to do with reading: basic reading skill, reading fluency skills, and reading comprehension. And if we drill down a little bit, when we're teaching reading, there are many things, but there are 5 components that we typically address. Phonological awareness, which, as you probably know, is how the letters go together to make sounds and how those sounds go together to make words. Phonics, vocabulary, fluency is reading rate and reading accuracy. So once you can use your phonological awareness, develop the phonics skills, you can decode the words, reading them accurately and with a higher rate or with expression. And then the last thing is comprehension. So all of this stuff has to happen before the student can actually read and make sense of what they are reading. So if we go back to these, the list of areas that determine the specific learning disability, we have basic reading skill. And I always look at that as the combination of phonemic awareness and phonics, and as sort of the sort of broader decoding and that sort of broader skill of putting the words together with the letters and the sounds. And then reading fluency and reading comprehension are also in there. So before I jump into the case law, I'm wondering if anyone has any questions. I'll look at the chat. Oh yes, encoding. We're going to talk about that. That's a really important thing. It does get left out, and it is rather new, I think, to talk about the orthographic processing and encoding as well as decoding it. It's going in 2 directions, but that's an important thing, and when I'm going to get into that quite a bit. All right, so the first case is Andrew F. versus Douglas County School District RE1. This is a Supreme Court case that came out in 2017. And this case updated the Supreme Court's earlier case. It was the Rowley case, which was about the level of progress that a student needs to make. What constitutes a free, appropriate public education? Is it, a very low level of progress, or does it have to be meaningful level of progress or maximum level of progress? And the court in the older case didn't get into the specifics of that. And in the Andrew case in 2017, they gave a more specific definition of what the substantive obligation schools have under the IDEA. So the court held that in order to meet this substantive obligation to provide a free, appropriate public education to a student with a disability, The school must offer an IEP that is reasonably calculated to enable a child to make progress appropriate in light of the child's circumstances. And this is more than a de minimis, which means at the minimum. I don't know how many, I took Latin for years. I never really stuck. But more than trivial, it has to be progress that is appropriate to the student. So the court said every child should have a chance to meet challenging objectives. And now this case, it's a few years old now, but it is really the foundation of where special education law is going. It's very, very individualized. This case repeats multiple times in the Supreme Court decision, the circumstances, the child's circumstances. We need to look at the child as an individual. And this is hard. It's really difficult to do because what do you need? You need really good evaluations, comprehensive evaluations that are going to tell you what is going on in the child's brain. So someone just asked, does that mean if a child is not able to be at the average of the class in reading, that is okay? No, it means that if the child can achieve grade level in reading, she needs to be taught to read at grade level. If there's a circumstance, a disability related circumstance that holds the child back from progressing with the class and going from grade to grade, then the IEP team has to establish meaningful, challenging goals for that student. So, oh, and here's a comment, a retired director now consulting. A lot of teachers at the secondary level do not have an understanding of the components of reading, focusing solely on comprehension. I find that all the time. And they also focus on reading strategies, things like previewing, checking the pictures, looking at bold letters, and it's not actually decoding the words and getting the meaning from the words. So that's Andrew F. The this is some useful language that I refer to quite a bit. So here, this is explaining how the case is saying that the IDEA requires that educational programming be appropriately ambitious in light of the student's circumstances. So when a student starts out in school, the expectation is that they will move from grade to grade alongside their peers in the general education curriculum. And again, if the student's disability prevents that, then the IEP team, the school district, is responsible for putting into place an individualized education program that may have different goals, but will still be challenging for the student and provide an appropriate education. And then I think this one is the most important. The court noted that the adequacy of a given IEP turns on the unique circumstances of the child for whom it was created. Again, emphasizing that individual attention to what the student needs. And this is why we have IEP teams, so that you have different perspectives coming together and deciding what the student needs in various ways. So that's Andrew F. This case, Doe v. Cape Elizabeth School Department, was in the District of Maine Court in 2014, and then it was brought to the First Circuit Court of Appeals, and the decision came down in 2016. So it actually came out before the Andrew case, but you can really see how the thinking is changing. It used to be that the courts really wouldn't look really wouldn't drill down into these eligibility issues. And here they're starting to do so. And then we get the Andrew case just a few months after this case came out. And so just as full disclosure, I worked on this case. I know this family very well. I'm happy to say that the student involved did go on to college and graduated, I think last year. I think she took 1 extra year due to COVID, and she is now teaching reading. So it was quite an experience for her to go through this process, and it was meaningful enough that she decided to choose that as her career. So the issue in this case was eligibility. The student was diagnosed with dyslexia. She had an IEP from 2nd grade to 7th grade, but because she was really strong academically, the school said she doesn't need special education. She's fine. She's getting really good grades. So they terminated her eligibility and gave her a 504 accommodations plan, but she continued to struggle with reading fluency. So the hearing officer found for the student, went to the district court, overturned, got appealed to the First Circuit Court, and then remanded back to the district court when we settled. So all of that is sort of the legal procedure that happens and why the case took so many years. But the ultimate decision in the case was that the school district failed to consider how the student's academic performance specifically related to her reading deficit in reading fluency. And that's because reading fluency is one of those criteria for eligibility for specific learning disability. So the court was saying that you can't dismiss a student simply because they are achieving overall. You have to look at their achievement in the area of deficit, in the area of disability. So the school must consider how the student's academic performance is specifically related to that disability in determining eligibility for special education. The school did not actually provide, during the student's 8th grade through high school, they did not provide any special ed services. The family provided it separately outside through tutoring, and ultimately the school district reimbursed them for that. Okay, now we'll get into this one, the Falmouth case. And this case has been a long time coming. When we worked on the Cape Elizabeth case, we were looking to build support for students with dyslexia, and it was a good case, and it dealt with that issue and really hammered down into the eligibility part of it. This one has to do with evaluation and with methodology. So the issue in the case is a free, appropriate public education. The student has dyslexia with a particularly deep deficit in orthographic processing. So symbol imagery was a real struggle for him. And he also has ADHD. So the parents enrolled him at the, actually, I'm gonna give you a little more information about this case. There's more than is on the slide. So this case was addressed, and there is somebody in the audience, I'll call you out, Deb, who worked on this case, and please type in the chat if there's anything you want me to add. So for 2 years, this case was addressed at the IEP team level. The student started school, was evaluated, and found eligible under OHI for, oh, and we got the parents. That's great. So the student was evaluated, got an IEP for OHI. His phonological processing was below average, and he has the very severe orthographic processing deficits. And the team noted that even though he met the standards for specific learning disability, he didn't need to have special services for reading. He didn't require special education for learning disabilities. So the IEP was initially for ADHD. And I'm sure many of you have been in this circumstance before. So the student's IEP and the services he received focused on behavior. And one of the things I found most interesting reading through this case was some of the testimony from the teachers who actually worked with the student. One of the teachers said, "I definitely saw him as a dysregulated kid. And so some days he would show up and stuff was tough. He had difficulty maintaining and meeting the classroom expectations." And they really looked at his behavior for quite a long time. The parents went and got an evaluation and went to the evaluator and were concerned with his social emotional state and his behavior. The evaluator identified that there may be something else going on here with his reading, with his with learning phonics and learning decoding and encoding. And she said that she recommended explicit and direct instruction, modeling, guided feedback in phonetic coding, decoding to improve phonological processing. So she's halfway there. At school, though, the student was receiving his special ed and his reading instruction, and they were using the benchmark assessment system, which I'm sure many of you, if you're into structured literacy, are well aware. This is the Fountas and Pinnell guided reading leveler. So it doesn't necessarily correspond to a program of structured literacy and measuring students' progress. It's specific to the Fountas and Pinnell program. So the student got to a level C on the benchmark assessment and got stuck. And the teacher testified that she had a hard time teaching a program that focused on phonics and measuring with the benchmark assessment. She said that the tricky part with the phonics program is that it sometimes doesn't always translate to the BAS level, and that's what I was adjusting my IEP to. So not only are they focusing on the student and his behavior in the classroom, and at this point he's little, he's first grade, they're trying to measure him with a tool that doesn't correspond to the type of instruction he's getting, and everything just sort of falls apart. The parents were very proactive. They got the student into an OG program for the summer. They had him evaluated again. This time he had an evaluation through a school in Cape Elizabeth, Maine. It's called the Ocasisco School. It is one of the leading schools in special purpose private schools in Maine for students with learning disabilities. So he was evaluated there, and the evaluators recommended that he have a structured literacy program that helps to teach the orthographic processing and will remediate the orthographic processing deficit. So the evaluator recommended the Linda Bell programs, Seeing Stars and LIPS. So Seeing Stars is one of very few programs that addresses the orthographic processing. A lot of programs say they address orthography, but that's not necessarily geared to a student with orthographic processing deficits. So the team at Cisco specifically recommended programming methodology that deals with the orthographic processing. So the parents they brought the evaluation to the school, requested it at the IEP team meeting. At first, the school district was on board, but as many of you brought up in the beginning, the teachers weren't trained. The school tried to bring in a consultant. It just didn't work. So the parents then decided, okay, well, we will provide the Linda Mood Bell separately outside of the public school, and the student was splitting his day, going to public school in the morning and then getting his reading instruction in the afternoon. Of course, this turned into a big fight, and there's a whole other aspect of this case that has to do with how the school district treated the family. I'm not going to get into that. That's a whole other presentation. But eventually, it got to the point when the parents decided that, they tried to bring him back into the public school, didn't work. The school went back to its old way of teaching with, I think they were using Wilson Foundations, which is not the full Wilson reading system, and Spire was the other program they were using. And they just kept hammering those programs, switching back and forth, and never really addressing the orthographic processing. And somebody has asked a question, would a child with a decoding disability on top of dyslexia benefit from using an OG program? That's, we can get to that. I don't know really the specific answer to that question, but I know the Orton-Gillingham programming, any of the Orton-Gillingham derived programs, especially the Wilson reading system, do address all of the phonics and phonemic awareness and phonics, which would be the decoding aspect of reading. So, and in this case, in this Phalon case, the student needed also the encoding and the orthographic processing aspect. So in their argument, the parents focused on the Andrew F. standard of careful consideration of the child's individual circumstances, and that this requires consideration of both the child's potential and the ability to remediate a particular disability using specialized instruction. Because the student in this case was a reasonable prospect to aim for grade level advancement, his IQ and all of his cognitive skills and abilities were in the average range. So he should have been able to advance from grade to grade, but for his reading deficit. The more robust standard of appropriateness, that the program needs to advance him from grade to grade, applies here. So the district is required to provide programming sufficient to permit the student to succeed in the general education curriculum. And the hearing officer in this case found that the school district failed to provide FAPE on several levels, but one of them was that the school district was using an ineffective method of teaching. And he equated the use of the ineffective method of teaching to holding the student's education to a lower standard. So because the student's orthographic processing deficit was not being remediated appropriately, the standard in his education program was lower than it should be. He was not being given appropriately ambitious goals. And that's a big deal in the case law, because we're looking at specifically what the school is doing. This is the accountability. This is how the services are being delivered, and how it's not just write it in the IEP. It's let's teach the child to read. Under the Andrew F. standard, the school can't hold a child to a lower academic standard than grade to grade advancement unless the child's disability makes it unreasonable to expect such advancement. The educational program must be appropriately ambitious in light of the student's circumstances and provide a chance to meet challenging objectives. So the hearing officer found for the parents, and the school district was very upset about this. And it's interesting because, let me see if I had another, I use the interesting language. This came on the heels of another case, same school district with almost the same facts. And this case, I think it went to hearing in 2017. And a different hearing officer who found that this school district spent 3 years of instruction, ineffective instruction with the student. The instruction did not remediate the student's orthographic processing disability and therefore did not allow him to make reasonable progress in learning how to read. The IEP could not leave open the possibility that the student would continue to receive inappropriate instruction. So in that case, the parents did something very similar. They pulled the student out, sent him to the special purpose school, and to receive Linda Mood Bell programming to, again, address the orthographic processing. Another case that was about the same time, but a different school district, found, again, for the parents and looked at the methodology that was being implemented as part of the student's IEP. The hearing officer noted, as Andrew F. directed school districts to focus on unique circumstances of students when developing IEPs and to provide access to instructional strategies based upon these unique circumstances. It was foreseeable that this student was essentially set up for failure during the 7th grade, given the reduction in direct instruction he was getting, along with a methodology that was not addressing his specific learning disability. So we had 2 cases at the hearing level that were telling school districts, you need to tailor the specially designed instruction to the unique needs of the student. And you're not doing that, so we're going to hold you accountable. So that's why Falmouth ran right to the district court, and they got smacked down again because I'll answer that question. The district court upheld the hearing officer's determination and went through they look at the case from scratch. They go through the entire record, and they found that, yes, the school had failed to provide FAPE. So the case was then appealed to the First Circuit, and the First Circuit affirmed the district court, and the parents were awarded reimbursement for tuition and evaluations. And to my understanding, the student is learning to read. So the useful language that comes out of this case is John, who's it's the pseudonym, it's Doe. So we use a pseudonym so that the student doesn't come back to haunt him later on. John was denied a FAPE by his IEP because John needed programming that would more explicitly target his orthographic processing deficits than Spire did due to the acuity of his deficit. An IEP that was reasonably calculated to enable the student to make progress had to address the reasons that the student might learn more slowly than his peers, namely his orthographic processing deficit. Each of the IEPs the school district developed during this time period was inadequate on that score. The district court thus did purport to root its findings on a consideration of the student's unique circumstances, which the district court supportably determined to be that John would face challenges learning to read because of his orthographic and phonological processing deficits. So here we have the First Circuit Court of Appeals, which has historically been unfriendly to parents, finding for the parents and saying the methodology does matter. And this student needed structured literacy to specifically address orthographic processing. And that's that. School pay for the tuition. And I just got a pop-up from the parents. He has learned to read, which is excellent, because I'm sure he's going to go on to do great things. And then a question, does this Maine case law apply outside its federal district? So what typically tends to happen is the districts will start to align themselves. So this case, it's not the first case to come out. There are a couple others, but it is the most recent. So as the districts each decide their own similar cases, somebody will eventually take it to the next step, to the Supreme Court. So if there is a circuit split where two circuits are at odds, they're not aligning, then someone will take it to the Supreme Court and get a definitive answer. But if you live in another circuit, if you're in Vermont, if you're in New York, Rhode Island, your circuit probably has a similar case, either have already come through or about to. And hopefully they'll all start to align and we won't have to go to the Supreme Court over this issue. Although it would be great to get current Supreme Court is probably not going to do it, but it'd be great to get a Supreme Court decision on structured literacy. So it does apply outside of the district in that it is an interpretation of federal law, and you can always use it and use this language as you're advocating for your student. So, all right, so here, this is another case. This is out of the District of Nevada, but it's very similar to the Falmouth case. And the parents in this case, interestingly, were prominent citizens of Las Vegas, and they got a lot of publicity. You can Google this case and there are news articles, there's a lot of opinion. They actually raised quite a bit of awareness with this case. So this came out in 2021. Again, the issue was free appropriate public education. The student in this case was considerably more impaired by disabilities than in the Falmouth case. So this student had a range of learning disabilities and some medical issues and needed a pretty high level of support and services in school. But the parents, again, took the proactive approach and they got an evaluation. They had asked the evaluator to make a recommendation. The evaluator recommended Orton Gillingham, and the school district, even though they had the information, they knew that the student needed the phonics and the structured literacy through this evaluation and other information. They didn't offer that. So the parents went through the hearing process and the appeal process, and the district court in Nevada found, well, before they found for the parents, they did something really interesting and ordered that there be expert testimony about the Orton Gillingham methodology. And that's what's particularly interesting about this case, is that the court actually asked for this information. and didn't just go through the record. So they had experts testify, and the questions that they looked at was, what is Orton-Gillingham? It's a research-based, validated methodology for teaching students with developmental dyslexia. Testified as to the prevalence and acceptance of the methodology and the efficacy of the Orton-Gillingham methodology or similar or derivative methodologies for children who have challenges like the student in this case. And then how teachers are trained in Orton-Gillingham. And this is a key part. And if I had more time, I would want to get into this, how the teachers are trained and how that, how much time does it take? What's the cost of the training? What's the cost of the programming? So the court did find for the parents, and they held that, again, the IEP team failed to consider the evaluations provided by the parents and failed to meaningfully consider the parents' concerns about this child's education. They ignored the recommendations of the professional evaluators. And because the student's needs were complex, she required a methodology that was research-based, systematic, cumulative, and rigorously implemented. So here we're getting the language of structured literacy appearing in a federal court decision. So this is I'm going to have to move a little bit faster here. So I'll just read this one. OR required a specific methodology in order to receive a FAPE. This did not say that she necessarily required the Orton-Gillingham methodology, but she did require an equivalent methodology that was research-based, systemic, and cumulative, and rigorously implemented. So that's the case out of Nevada. So I'm gonna move ahead. So one of the things that has happened it's really the past 20 years or so since the publication of the National Reading Panel report in 2000, there was kind of an upwelling of interest in dyslexia and improving services for students with dyslexia. So the trend in the new legislation at the state level, because we have the federal level with the law, but the states can also enact their own laws, which can increase or enhance or add to students' rights and schools' obligations, but cannot take away from them. So the state law follows the federal law, and it can add rights and obligations, but it can't take anything away. So the way that this has been going is adding in multi-tiered systems of screening and earlier, so early intervention, looking at kids in kindergarten, first grade, even pre-kindergarten for early signs of reading difficulties. Technical support for schools, explicit instruction, changes in teacher preparation, and changes and improvement in professional development requirements and opportunities for teachers. So this is all really good news as states bring these types of laws and regulations in, and schools have to, motorcycles by, sorry. So schools have to screen students earlier and respond to the results of the screening, and they need to bring in the structured literacy and explicit instruction. All of this is going to benefit our kids. So a couple of states that have really strong legislation, interestingly, Arkansas, Arkansas requires coverage of dyslexia in teacher preparation programs. So this is something that didn't happen. I mean, during the reading wars back in the 80s and 90s, and then the Don't Say Dyslexia era, teachers who were learning to be students who were learning to be teachers were not taught about dyslexia. They were not taught about using different methodologies for teaching students who have reading difficulties. So this is a big one, and one of the things I think is most important going forward with state legislation is get the changes to the teacher certification requirements, saying they need to have some kind of training, some kind of coursework in dyslexia and an understanding of how reading works in the brain. Arkansas also has a dyslexia specialist at the state level who provides a resource guide. And I'll just say New Hampshire has this as well. It's a really excellent resource guide that's available to schools, parents, anybody who's interested. Technical assistance to schools and enforcement of the rules and regulations around screening and teacher preparation. The local education agency has to provide 2 levels of screening. So general screening and then level 2, according to the resource guide. Parents are informed and services are provided at either, if the student is identified at either level. And then every local education agency has at least one dyslexia interventionist, so someone trained to teach students with dyslexia. Mississippi, similarly, requires screening with the state-approved instrument. Children who are identified through the screening as potentially at risk for having dyslexia are fully evaluated for IDEA or Section 504. If they are found eligible, they can be enrolled in the local agency dyslexia program or receive a scholarship to another district's dyslexia program. And they also have brought in the state has brought in pilot programs for testing and provision of services to students with dyslexia who are not qualified for special education, and again provides an administrator and dyslexia therapist for the local area schools. Whether or not these are funded, legislative provisions are funded is a question that I don't have the answer to, but they're really strong, and you'll be surprised about this next one. Texas has the strongest dyslexia legislation. It requires certification for dyslexia therapists and dyslexia practitioners. There's an advisory committee that provides the certification, teacher preparation requirements, state training opportunities, state compliance enforcement of local education agencies, screening and intervention requirements, screening twice, kindergarten and first grade, and evaluation of students who are identified at risk through screening. There's a detailed handbook, certified dyslexia therapist at each. They have regional education, so it's not at each school, local educational agency, but the regional, so they probably share. Has established extra funding for specified qualifications as a dyslexia therapist, and also IEPs, 504 plans, grants for developing a separate K-3 reading program, statewide committee to develop a classroom technology plan, and alternate assessments for students with reading needs through Section 504. So Texas wins. And now we get to the good part. In Maine, we do have dyslexia legislation. There is screening, not for all of the children, only for teacher identified children. And sometimes that screening kind of gets done and then gets put in the file. The parents don't see it. It may be mentioned at a parent-teacher conference, but there's no requirement that it needs to be followed up with a full evaluation if the student is at risk. Maine does offer Title I services for students identified as having difficulties in reading, but the screening provision is pretty weak. There is a state-level dyslexia coordinator, and she does provide professional development and materials. There's a good website, and we're hoping here in Maine to improve on this. New Hampshire has some pretty strong dyslexia legislation. It requires the state to provide a trained reading specialist and the resource guide for technical assistance, and that's what this is. And the guide goes through how to identify and assist students with a wide variety of learning disabilities. And when they do the screening, there is a parental notification requirement and interventions. So if the student comes up as having at risk of dyslexia, the parents get notified and interventions get put in place. And then Vermont identifies dyslexia as a specific learning disability, and they have statutory authority to pass regulations, but I didn't find anything else. And I know there were a couple of Vermont people here, so if I've missed something, please let me know. I am a former Vermont resident. I went to Middlebury, so I feel sad that one of my favorite states is kind of weak when it comes to dyslexia legislation. I threw Massachusetts in here as well. I know there are a few people from Massachusetts. So Massachusetts requires the state, subject to appropriation, so if there's money, issue guidelines to assist the local education agencies in developing screening procedures or protocols for students that demonstrate one or more potential indicators of a neurological learning disability, including but not limited to dyslexia. And I was trying to put Massachusetts, to me, I guess it's associated with Dunkin' Donuts, and I couldn't use the Dunkin' logo, so I just put in these random donuts. That's why it's there. So before I get to this, actually we're getting kind of late. Does anyone have any, anyone have any questions? Looks like people are asking and answering questions. Right, so despite the good news on the state legislative front and the few good cases that are bringing structured literacy and teaching methodology into the case law, school districts still win the majority of these cases. And it's unfortunate, but it's the way it is. So these are three other cases that had similar facts to the ones that I went over, where the parents lost. And you can look them up, but they're really, I think it's just that the facts didn't align perfectly. But this one from the Ninth Circuit, which is the same as that Nevada case, said that districts need not specify an instructional method unless that method is necessary to enable a student to receive a FAPE. So this is in line with the case out of Las Vegas. In that case, the methodology was necessary for the student to receive a free, appropriate public education. And same with the Falmouth case. the student needed to have the Linda Mood Bell methodology. So that one's not too bad, but the parents still lost. Right. So when it comes to advocating for your student or other students, you can use this information to bolster your advocacy. But I have the these like 3 things to consider, as you go through the advocacy. And somebody just asked, why do parents always have to battle? And I don't know the answer to that. I got into special education law because I thought, wouldn't it be great to help school districts and parents come together and make the right kind of plan for kids? And it is one of the most contentious areas of law. Like, I think divorce might be the next most contentious area of law. I don't know why. It probably has to do with money. So when you are advocating for your student, you want to ask questions. If your student is very young, you want to find out, have they done the screening? What were the results? Ask to see any of the paperwork, ask what interventions they're putting in if the child has been flagged as needing additional Title I instruction or additional help, or keep an eye on him or her, because you want to get the structured literacy in place as soon as possible. And we all know that the longer you wait, the bigger that gap gets. A student who is flagged as having a risk of dyslexia, and ask for an evaluation. If you get your kindergartner screening back and it says, yeah, he's got a few markers for possibly having dyslexia, you want that full neuropsychological evaluation. You want to look at the processing and the pre-reading and what is going on with the student, and then again get that methodology in place as quickly as possible. And then you want to, and this is where these cases come in, and also the state law, you want to tie the requested methodology and the requested services specifically to the results of the evaluation. So if the child has phonological processing, you want to get an Orton-Gillingham based program in right away. If there's a orthographic processing deficit or dual deficit, you want to get a program like Seeing Stars or Lips put in place right away, and ask for it. Ask the teacher what she's trained in. Ask the school district, will they send a cohort of teachers to be trained? Can they hire an Orton-Gillingham person? Can they survey all of the teachers they have in the school district and find out who is trained and bring in the trained person? The schools get money to hire people, train people, and I do this all the time where I ask, like, can you survey all of your literacy teachers and find out if anyone's done the Orton-Gillingham training, who has it? Go through your files and find it. And if you can't find someone, it's time to start thinking about sending people out for training or bringing people in. I was living in York, Maine for about 15 years, and I had at one point 9 cases of kids who had gotten into middle school and couldn't read. And it took several cases and several years, but that school district hired new teachers for the younger grades and for the middle school. And those teachers were trained in Orton-Gillingham and in Linda Mood Bell, and it's made a world of difference. I recently had an IEP meeting with one of the students I've been following since he was in second or third grade, and he's in high school now, and he's doing fantastic and getting ready to go to college, all because he had the right kind of instruction. A big thing is progress monitoring. And my friend Amy Catling, I didn't see her here. This is her. She's a special education advocate in New Hampshire and Maine. And her big thing is ask for the data. You want to get the data. How are they monitoring progress? How often are they looking at it? Does the progress monitoring tool correspond with the program they're using? And are they also using global progress monitoring, things like the FAR and fluency probes and whatnot? The next set is seek outside help. Don't go it alone. Talk to your evaluators. A lot of times parents will start with the pediatrician, and the pediatrician can recommend a neuropsychologist or someone who can do an evaluation. If the family has good health insurance, sometimes that's covered. I know a lot of people don't trust the school district, and the school district's evaluation, they're sometimes falling short. So getting a really good evaluation from a solid professional who's experienced in looking at kids with reading disabilities is key. And that was key in all of the cases that were found for the parents. The teachers, sometimes the teachers can be your best advocate in the IEP process. And just like in the Falmouth case, if the teacher is getting frustrated, and if the teacher is just throwing up her hands and saying, I don't know what to do, ask them to go to bat for the student, to bring these things up at staffing meetings, at team meetings, maybe not in front of the full IEP team if they're uncomfortable, but bring it up. Do some research, try advocate for themselves to get the help they need and the resources they need. And then special education advocates abound. I mentioned my close friend, Amy Catling, who's with the IDA. Deb Davis is on here as well. I know there are some excellent people in New Hampshire and Massachusetts. So I'd be happy to, if someone wants to contact me, pass along some names and information. But a special ed advocate can come to your meetings and help talk the language and answer questions, ask questions, and can really be a benefit, especially if your school district is putting up a fight. An advocate can help you sort of navigate the process so that you set the case up if you do need to go to a hearing or litigation eventually. A lot of great resources out there. Obviously, IDA has fantastic resources on the website. I recommend reading as much as you can about dyslexia or listening to audiobooks. Sally Shaywitz, Decoding Dyslexia, is always the one I recommend for everyone to get started with. And then the final block is listen to your child. I find that the student knows what's going on more so than anyone else, and listen to what your child is saying about their attitude towards school. Are they engaged with school? Are they interested in the content area that they're learning? Do they come home excited about learning about space or reading a story, or are they really into math? What is it that they are finding enjoyable at school? What are they finding is challenging? Behavior is a huge predictor. If the student, like in the Falmouth case, the kid struggles were really blamed on his ADHD and his behavior. If the student is acting out, that behavior is likely a symptom of something else going on. And so many kids with reading struggles will act out in order to avoid reading or deflect attention from from their deficit. So you want to pay attention to your child's attitude toward reading and toward school in general. An emergency situation is if the student starts to refuse to go to school at all. And I've seen this happen in dyslexia cases where the child just can't cope and they start refusing to go to school. So that's a big part of it. And, the IEP, and, as we're going through these cases and the laws, everything is coming together to create a program, to require that schools create a program that is individual to the student, and the student needs to be at the center of that. So I always like to remind people to listen to the child and trust the child. And then the bad news is that time is running out, and reading disabilities are, even though they're the most understood and effectively corrected learning disability, students are still under-identified and underserved. You want to get help as soon as possible. The longer the student goes without the right reading instruction, the more they fall behind. And by the time they get to third grade, they need to start reading to learn, and you rarely can close the gap. So there's a lot of questions going by, and I don't think I'm going to be able to. Oh, here's a good one. I am going to, so I want to answer a few questions. So, keep them coming, and hopefully in the last few minutes we can get to them. So this question is, what about a 5th grade student who has orthographic processing problems, whose school uses the Fontes and Pinnell model, IQ of 120 and standard scores in reading, writing in the 80s and 90s, but because their scores are within the average range, average range, the student is dismissed from special education. So that sounds like the kind of case where I would have a reading specialist, someone who is trained in identifying learning disabilities in reading, to do a complete evaluation of all of the areas of reading and find out if there's something that corresponds to those 3 requirements in the IDEA, and link that to the student's need for special education. You don't want to let the school district say, oh, he's achieving fine, he's really smart, he can compensate for it. No, if he's struggling with decoding and encoding and symbol imagery with the orthographic processing, then they need to address that. It is really hard if the student, there is the, I'm trying to answer this sort of off the cuff, but I'm sure you've all heard of the twice exceptional, the 2E students. So you have a student with a really high IQ and then relatively lower scores. That doesn't usually qualify them. So if all of the scores are in the average range or above, the student isn't going to qualify unless you can drill down and find something that's really impacting them. So that might be a tough one, but I hate Fontes and Pinnell for teaching students with dyslexia. It's just so wrong. So I don't know if that addressed that. I've got 4 new ones. Let's see. So people have been putting in links to Wright's Law, which I put on here, Vermont Family Network, and then some Maine Parent Federation. Yeah, and there is a problem here. So schools sometimes will say that teachers are certified, but they're not certified in Orton, Gillingham, or Wilson. Those certifications, as many of you already know, are like graduate level courses, like full year courses. But they may be trained in these methodologies. They may have done an abbreviated training, or had a colleague or someone from the district train them. So the school will say, oh yeah, we have people certified or trained in these programs, but they're not actually certified. And you can check that. All of that stuff is public information. That No Child Left Behind was really trying to get highly qualified teachers. So that's something you can ask for. What is the certification? When did the teacher do it? And can I see their certificate? So I think we are out of time. I'm gonna stop sharing my screen.
Thank you so much, Amy. That was so enlightening. I am taking
Welcome.
away a lot of nuggets.
I hope so. I went really fast at the end there. And if anybody has any other questions, please don't hesitate to reach out. I'm happy to chat.
That's wonderful. Thank you so much. I appreciate you putting it in language that was easier to understand and follow along. So a very nice presentation. And before we go, I would like to tell you about some upcoming Read for Parents. June 14th, we'll have Faith Borkowski join us, and her topic is To Be Determined. If you're on our mailing list, keep an eye on your email and we'll share this information shortly. And then in August, we'll discuss phonological awareness with Lucy Hart-Paulson. And October 11th, we will explore morphology with Dr. Deb Glazer. So please complete our survey at the end of the session. And thank you once again, Amy, for being our guest tonight.
Thank you for having me.